Once you start down the path of a direct-to-consumer model, you suddenly have, FDA promotional standard requirements, state pharmacy requirements, telemedicine overlay, potential for False Claims Act exposure. That particularly popular approach to drug distribution and drug access at this point in time makes a lot of sense for the consumer, for the patients, and also for the drug sponsors, but has with it a lot of risk.
Hello. Welcome to a very special episode of FDA Watch. As you know, we're the only independent podcast about FDA. I'm your host, Wayne Pines. I'm very excited about this episode. It's the first installment in one of our signature multi-episode series that we produce in collaboration with law firms or other organizations. This particular one we're calling Drug Pricing Pressure: Navigating Regulatory Complexity. And we're going to be looking, since we're FDA Watch, we're going to be exploring the intersection of FDA regulatory strategy, competition. We're going to be looking at antitrust, some of the areas that are a little bit outside of the FDA world, but that are affected by the FDA world, and that's what we're going to be focusing on. Drug pricing, obviously, is a huge, huge issue in this country as it is worldwide. Historically, FDA has avoided having anything to do with drug pricing. When I was at FDA, we were specifically trained to avoid anything having to do with prices. It's not something that FDA historically has dealt with. That has changed somewhat. FDA's generic drug policy, for example, in advocating the quick approval of generic drugs, obviously is based on the fact that generic drugs save money. The same thing applies to biosimilars. Nowadays, there's been a little bit of a shift, as we all, I think, recognize, and this is not intended to be a criticism, but politics and issues like drug pricing are now more involved with FDA. And I think we saw that happening in earlier administrations. I don't want to attribute that just to this particular administration. I once heard Peter Marks talk about the high price, for example, of certain biologic products, some of the cell and gene therapies, and said, we at FDA need to do something about that. We can't have cell and gene therapies that are so expensive. Obviously, the FDA does not develop those products, but nevertheless, there was a recognition that some of the cell and gene therapies are ultra expensive. FDA has never, and I hope will never, get involved with setting any particular price for a drug. But we are going to talk today about how regulatory issues and how pricing pressure, real-world regulatory decision-making, how drug pricing can migrate into government investigations and enforcement, how drug costs should be assessed in corporate transactions, licenses, collaborations, and other industry deals. We have the support today, not just of one, but of two organizations. The law firm of White Case, which has an outstanding FDA practice, a life sciences group, and BRG, which helps clients navigate financial issues, compliance issues, transaction issues involving drug prices. We'll meet our guest in just a moment. In future episodes in this series, we're going to take a deep dive into FDA when it comes to drug pricing per se, pricing strategies as they apply to enforcement risks and investigations, and transactions and deals. If you subscribe to FDA Watch, and you can do so by going to fdawatch.net, then you will get a notice in your email whenever we have this series or whenever we have any episode. So I encourage you to go to fdawatch.net and subscribe. It's very, very simple, and you can't beat the price. It's free. Our first guest is Bethany Hills. She's a regulatory partner at White Case. Her practice integrates product regulation, compliance, corporate governance, enforcement, risk management. She advises global life science, healthcare, and technology companies and others on complex regulatory challenges. Welcome to our podcast.
Great to be here.
Rahul Rao brings extensive experience in antitrust enforcement in litigation and policy to White Case. He served as deputy director of the Federal Trade Commission's Bureau of Competition from 2022 to 2025. He oversaw the Bureau's pharma and life sciences enforcement efforts. He also previously was managing assistant attorney general in the antitrust division of the Washington State Attorney General's office. He did that from 2018 to 2022. So welcome to FDA Watch, Rahul.
Thank you, Wayne. Looking forward to having this conversation.
John Barkett is managing director in BRG's healthcare transactions and strategy practice. He counsels health plans, hospital systems, life science companies, and financial institutions on a range of issues related to transactions and public policy in the healthcare space. Before joining BRG, John served as a senior policy advisor for healthcare delivery system reform on the White House Domestic Policy Council. So welcome to FDA Watch, John. Good to see you here.
It's a pleasure to be here with you.
My first question is to Bethany. Obviously, drug prices are affected by the drug approval process, by what's going on at FDA. FDA makes decisions about the approval pathway, exclusivity, labeling, REMS strategy, timing of approvals, and all of these can materially affect competition and therefore pricing. It can also affect the policymakers' willingness to pursue drug pricing reform. So Bethany, let me start out with you and ask you a general question. What are the earliest FDA and product strategy decisions that actually determine prices?
Sure, Wayne. There is probably about 4 buckets of regulatory strategy decisions that are definitely going to be pricing drivers later in the drug product development cycle. You mentioned one already, the approval pathway selection. So we've seen quite a large uptick of 505(b)(2), but also choosing between the B1 pathway with a new chemical entity, the B2 pathway, BLA, is going to help determine your exclusivity type and whether you're going to have exclusivities once you get the product on the market, but also the extent of the data package, so how long it takes to develop the product and the speed to market. And all of these things lead to ultimate pricing decisions. So that has really been a historic process for developing regulatory pathway pricing drivers. Another one that we look at a lot is the indication selection and how you scope the label. Those are pricing levers that are just disguised as clinical decisions, right? A narrower indication might speed approval, but then it also limits the circumstances, the reimbursable population, and we have issues that we can play into with like breakthrough therapy designation or accelerated approval that may then limit the label breadth, but also then down the line has later pricing implications. So paying attention to that from an FDA regulatory standpoint is definitely going to have pricing impacts. I mentioned a minute ago the exclusivity strategy. So this is one that has also been a historic pricing lever from an FDA regulatory perspective. Do we get an NCE exclusivity? Are we using orphan drug designation? Are there pediatric exclusivities? There are lots of different places where we can leverage regulatory exclusivities or data exclusivities to extend the product's competition moment on the market. And that does have a pricing impact overall. And then the last bucket that I really think is evolved over the last 20 years is the use of REMS programs. These really do affect distribution channels, prescriber certifications. We even see it impacting patient registries and how you actually get patients onto the drugs and how accessible it is. And all of those come at a cost and have pricing impact. And so I think understanding how a REMS is going to be used, structured, and whether or not it's even required is going to be a really big a lever from the FDA regulatory perspective that has an impact on pricing.
Just for our audience who don't know what a REMS is the risk mitigation strategy, which FDA can impose and which makes certain drugs eligible for approval even when they have relatively high risks, if there are risk mitigation strategies. John, could you add on to what Bethany just said?
I can. I thought it was really well said, Bethany. And I would point out that whereas Bethany covered the FDA decisions, like once a product gets to market, the pricing is going to play out in the context of whatever the market rules are, and the population and payer norms and rules are for that specific drug. So to give examples of that, choosing between a small molecule versus a biologic drug. Well, now in the Medicare program, if it's a high revenue drug, you now have potential Inflation Reduction Act Medicare negotiation programs that differ depending on whether it's a small molecule or a biologic. The route of administration might determine if it's a Medicare Part B versus a Medicare Part D drug. With Part B, you're going to be dealing with one way in which you get reimbursed for that product. It involves buying and billing by a provider, and can be negotiated. It involves this the shorthand is ASP plus 6, but it involves a markup by the provider, which creates incentives for higher prices so that the provider is more likely to choose your drug. If it's Part D, then we're dealing with, at least as of recently, a rebate-driven, PBM-mediated type of negotiations and reimbursements, along with the very sort of particular aspects of the Medicare Part D program and how certain rebates have to be provided to Medicare as well. So one other example is, say, like orphan drug. Orphan drugs these days are, if you have that designation, not only do you get certain exclusivities, but you also get consideration in various Medicare programs, not just the Inflation Reduction Act's drug price negotiation program, but also in some of the recent models and programs that the Trump administration has been touting. Some of their tariff plans had exceptions for orphan drugs. So all of these payer-specific or market-specific rules of the relevant market for this drug also will determine how your pricing shakes out.
Yeah, Rahul, I want to get you involved and ask you about antitrust. How do all the things that John and Bethany were just talking about affect antitrust strategy? What would it attract antitrust scrutiny?
Well, thanks, Wayne. So just taking a step back, right, in terms of antitrust. Antitrust regulators are, really simply put, they're concerned with anything that reduces competition. In the pharma space, that may include things like artificially extending patent monopolies, actions that may thwart generic entry, or even anything that influences drug price negotiation. Historically, antitrust enforcers cared mostly about, things like overlaps of commercialized products in pharma M&A, or something like price fixing. What's interesting about pharma today is that many current sources of antitrust risk aren't obviously problematic on their face. They are business and regulatory decisions that each look reasonable in isolation, but possibly create a pattern that raises competition concerns. Some of these issues include, life cycle management, indication sequencing, orphan designation. And really at a high level, we can take those on just, one by one. Product hopping, for example, is one of the life cycle management strategies that gets a lot of attention. The pattern here is that a company introduces a reformulated product. It's a new delivery mechanism. It's an extended release version. And it's timed to when generic competition is about to arrive on the original. These companies then use their relationships with payers and pharmacy benefit managers to migrate patients to the new version before automatic generic substitution becomes available. The issue is that when this hard switching is timed in a way that anticipates and frustrates generic entry, it can raise a viable antitrust claim. And that may be true even when the FDA approvals are entirely lawful. And that's not the issue. The antitrust problem is about what the company does next. Do they withdraw the old version from the market before the generic enters? Moving patients to new drugs that don't have automatic substitution at the pharmacy level? Do they use contracting leverage with payers to complete the patient migration before the generic can establish a foothold? The reformulation is the mechanism. The plan to shift patients out of the reach of generics is the concerning conduct. Another area is indication sequencing. This is, layering new protected indications onto a compound, as the core patient population ages off. Here, each new indication from an FDA perspective may be clinically legitimate on its own, but the antitrust analysis runs on the aggregate effect. If the sequence extends commercial exclusivity materially beyond what the original patent position would have supported, you can find yourself with real antitrust concern. And I heard, I think John mentioned something about, orphan designations, right? This was an act designed to incentivize development for genuine rare disease populations. The issue here is what happens when a company obtains orphan designation for a subpopulation of what is really a mainstream disease? Is that orphan indication a gateway to a broader market? Let's say because the designation creates some clinical comfort in terms of the prescriber prescribing it more broadly off-label. So the issue is what happens when a company strategically defines a subpopulation, not for any clinically meaningful reason, but because it has a derivative effect on the market. And when there are other issues too, but the thread running through all of these is the same. The antitrust question isn't about whether any individual regulatory or business decision was permissible at a technical level. A lot of them are. The question is whether the pattern in aggregate or even a single decision taken in isolation serves no legitimate business purpose other than to keep a competitor out. That's the lens enforcers and plaintiffs are bringing to these issues. And it's one of the reasons that FDA strategy and competition strategy need to be developed in sync.
Now, John, I want to follow up with you on that. Where is the line between lawful regulatory strategy and conduct that either regulators or plaintiffs, let's say, may characterize as distorting competition? Where's that line?
Well, when I was a policymaker, I viewed it through a political lens, and it felt like the sum total of all the different things that Rahul was just talking about, these various strategies which may have been technically legal but felt anti-competitive. It felt like, okay, if antitrust enforcement isn't stopping these things from happening, then we might consider regulatory remedies. And if we haven't been able to figure those out either, then we're going to need some sort of new law or legislation. I worked on the Inflation Reduction Act, and I would say that law was the result of frustrations among policymakers of antitrust lines being crossed impressionistically, but even if not technically. So while I will defer to Rahul on the exact line that has to be crossed for antitrust, I will say that politically, the line to me is when the spirit of Hatch-Waxman is violated. Let me explain what I mean by that. Hatch-Waxman was a law that came around decades ago that created this sort of basic bargain with the industry. It said, we'll give you exclusivities for new drugs you bring to market, but we got to make sure generic competition does come into play after a certain amount of time. And the spirit of that law can be violated if you're engaging in some of the practices that Rahul was talking about. So I think when that line gets crossed, and it gets crossed enough times, then it's not just about antitrust regulators coming and knocking at your door. It's also about Congress taking a lot more interest in that. So, Rahul, maybe I could turn it back over to you to sort of address that as well, though.
Yeah, no, John, thanks. That was actually, very well put. And I think, Wayne, I think part of the challenge here is the line itself is not as, clearly demarcated as maybe we would like. There's clearly things that are on one end of the spectrum and clearly things on the other end of the spectrum. Where that tipping point is is a little bit more unclear at times. I think if we were to, put it into words, I think the line is where lawful regulatory strategy, when it's strategy designed to succeed at the regulatory objective, that's good. That's fine. That becomes an antitrust liability when that regulatory act is somehow weaponized to exclude or to simply exclude or frustrate a competitor rather than to achieve a genuine regulatory outcome. I mean, I know that's a somewhat wishy-washy, you know it when you see it type approach, but I think that's how you determine the parameters or where the line is.
There are almost too many issues to deal with here, and I'd like to do a little bit of a deeper dive into some of them. But let me ask all three of you a general overview question. You all deal with clients. You all advise clients. Starting with you, Bethany, how do you advise clients on all the factors that we've been talking about, all the factors that enter into drug pricing, into drug development? How do you advise a client on all these matters? What's the approach?
I think it's really hard right now, Wayne. Things have changed a lot in the last 18 months. The world is a different world than we might have been used to. And one thing that I wanted to play off from what John and Rahul had just mentioned is the Commissioner's National Priority Voucher Program. And you mentioned this at the beginning, at the outset. Just a really interesting historical framework is that we work from a position where the FDA really has not gotten involved in pricing strategy. And that has changed. And I think the Commissioner's Priority Voucher Program is one of those great examples. It's now a carrot and a stick dynamic that we weren't used to seeing. And we're seeing actions taken by FDA that are then resulting in direct White House announcements relating to pricing. So we know that one voucher recipient actually made a coordinated announcement with the White House about bringing a particular drug to market, while at the same time signing on for lowering a different drug of theirs in their portfolio, the price of that drug. And we've seen also, participants in negotiations with the White House agreeing to lower their prices in exchange for getting onto the voucher program and the FDA. And so the way I would sum that component up is when you're talking about how do you think about managing this at this point in time and really bringing together your regulatory, your clinical, your pricing, your launch, and also your ongoing compliance strategy. All of this needs to be tied together. Is you do have to be dynamic with the current state of play and understand and see the trends as to where some things are going. And we can't function from a rule that FDA is not going to be involved in this or really push on pricing levers. We do see the trend that is changing. And so I think that this pricing environment, this administration is making it a new world for our clients to be thinking about. The other thing that I would mention is we also have touched on this a little bit, but the most favored nation pricing environment, which is another layer of compliance issues with tariff-based compliance. It's directly intersecting with global regulatory strategies. And that also is pulling back into issues that are coming right smack into the regulatory framework. How the product's labeled, what the sequencing is, what's on the label, your commercial relationships, the supply chain, how legal's interacting, how compliance is handing that off. These things cannot be handled. You can't look at most favored nation pricing and these global issues in the context of just government affairs. It really needs to be a multi-stakeholder group that is coming together and thinking about all of the complexities at one point in time, and not relying on one being the primary complexity driver.
Rahul, I want to ask you the same question. How do you navigate this? How do you advise a client to navigate in this complex environment? And as Bethany just pointed out, it's a changing environment. It's different today than it was 18 months ago. Who knows what it's going to be like 18 months from now? And all of our clients, need to do long-term planning, especially in the pharmaceutical area, the biologics area. You have to do long-term planning. How do you advise a client to navigate?
That the uncertainty of what the next 18 months or even the next 6 months looks like does present challenges for business. Thinking about it, from my antitrust perspective, I think one of the things that's really important for business to internalize at this point is that the pressure on access issues as well as pricing issues, the intensity of that focus, it's not going away. This is not a cyclical concern, and this is also bipartisan. And so, I think part of how you navigate that is to accept that this is something that's going to be a topic and an area of focus for the foreseeable future. And one of the things that is important to do, and one of the things that's important to recognize, is that government, law enforcement writ large, has viewed antitrust as a very effective tool to manage what is seen as out of control pricing. And so my advice, counsel to business, is that it's critical to build an antitrust risk register alongside your IP strategy. And what I mean by this is that every major lifecycle management decision, whether it's reformulation, new indication filing, patent listing, citizen petition, whatever it may be, it needs to be assessed not just for the FDA and the IP merit, but it also needs to be viewed through an antitrust lens as to whether it raises a monopolization issue or can trigger an FTC investigation. This is, from my perspective, not a theoretical risk management issue anymore. It's honestly, it's table stakes, especially for certain high revenue products. And so that would be my counsel to clients is, build in the antitrust review, at least the visibility, very early in the process, if not at the beginning.
John, same question. How do you navigate? How do you advise your clients to navigate in this environment?
Well, it's challenging to think about manufacturer embarking on a new drug development process, because it might be 7 to 10 years before that drug makes it to market. And as Bethany noted, like the last 18 months have been radically different. Who knows where we're going to be 7 years from now? I do think there's some wisdom in thinking the following, that even though there is a lot of zeal right now for drug pricing reform, the support for innovating new treatments and cures is also still very strong amongst policymakers. Just the recent stories that have come out about new cures that are being developed or treatments being developed for cancers in particular are very exciting, and members of Congress, presidents, et cetera, they want to support those types of things. I think in the long run, you can rely on policymakers over time being able to balance the desire to lower prices now and increase access now with the desire to have treatments and cures in the long run. And so keep doing what you're doing. But as I mentioned earlier, I think you have to, just like Rahul said, keep a antitrust risk register, I think was the term you used, Rahul. I think a political risk register has to be kept as well. And this is, again, a little bit more impressionistic, but if you find yourself really kind of violating the spirit of our laws and frameworks that govern competition, especially in the drug space, which has these various IP protections and exclusivities, then I might keep those in mind the next time, say, Congress is pursuing health reform or deficit reduction. That's going to have to happen in a few years. They're going to be looking for the most justifiable cuts they can make. And if you're, in flagrant violation of these competitive rules that we have, then, you might be the first one that gets a knock on the door.
Yeah, it certainly is a complex area. I'm going to take a short break now. Don't go anywhere. We'll be right back. And we're back. We're talking with Bethany Hills and Rahul Rao from White Case, with John Barkett from BRG. I want to ask a question about mistakes. What mistakes do you see your clients making that are avoidable, that where they unintentional? Obviously, a mistake by definition is unintentional. Nobody makes a mistake deliberately. What kind of mistakes do you see your clients making that they should have anticipated and could have avoided? I'm going to start with you again, Bethany, if I might.
Yeah, I think those that are ultimately leading to problems in the competition space and in pricing can be rooted often back to the FDA regulatory strategy that was selected. A common risk pattern that we see relates to the REMS program. So those are the risk mitigation strategies that we talked about earlier. And as you're developing that, and if you are unfortunate enough to have one of them in your drug profile, you try to make it clinically appropriate. But then there's the way that it's actually commercially constructed. It can create barriers to access. You may need to have a specialty pharmacy network set up. You may need to require extensive prescriber certifications. You might need to be mandating patient enrollment. All of those things might be justified by the risk profile of the drug, and also, really being responsive to what FDA is asking for from the context of doing this risk mitigation strategy. But what also is perceived as, protective from the FDA patient safety standpoint can also be considered anti-competitive from the enforcers. And so if it's making it difficult or too expensive for generic entrants to actually model that REMS program as it becomes time to do that and they're available to enter the market, you might find that what was a defensible safety program, it really met all of FDA's requirements and really made sense for the profile of the drug, might often end up with a pricing problem and even an enforcement risk down the line. So we do see that. Another area that's sort of a reoccurring fact pattern is in the direct-to-consumer distribution strategies. This is an area that is really hot, has a lot of focus from FDA for enforcement, from the White House for purposes of pricing, and it's an increasingly popular way to try and access the consumer market and also link it up with some really complex overlays with digital health tools, linking up to telemedicine, and having a direct-to-consumer model in order to actually have your medicine prescribed and to have it available to consumers may not always be an option for every drug. Not all consumers can pay out of pocket. But once you start down the path of a direct-to-consumer model, and as complicated as that might be, you suddenly have FDA promotional standard requirements, state pharmacy requirements, telemedicine overlay, a lot of potential for False Claims Act exposure. And so that particularly popular approach to drug distribution and drug access at this point in time makes a lot of sense for the consumer, for the patients, and also for the drug sponsors, but has with it a lot of risk.
Yeah, what do your instincts tell you about the future of direct-to-consumer? We use the term direct-to-consumer in a number of contexts. This is direct-to-consumer marketing, not direct-to-consumer advertising per se, although advertising involved, but it's actually making drugs available directly to the consumer. What do your instincts tell you about the future of that means of marketing?
I think direct-to-consumer access, profiling, and then marketing and advertising, right? That promotion, that whole system in order of getting drugs into a patient's hands through patient demand as opposed to through a learned intermediary through that prescriber channel is going to continue to be popular. I think it's what people want. And post-COVID, this is an area of access that is a lot more familiar to everyone through telemedicine and through digital health access. But we do have, I think it's going to be a boomerang or a pendulum, maybe is the better way to say it, because there is very high chances that these structures and systems are going to fall down around some of the compliance frameworks, the referrals, the anti-kickback, some of the competition-related frameworks, and they're really complex to maintain in a way that keeps all of the different matrices in order and in a compliant fashion, especially if they are driven by the drug sponsor. I think that those are very challenging. And so I see a pendulum that will be coming in the future where it'll kind of pull back after there's some strong enforcement actions. That's my anticipation.
Rahul, I want to ask you the same question I asked Bethany a few minutes ago. It has to do with mistakes. What mistakes, and again, they're inadvertent by definition, what mistakes are your clients making that they could have avoided, but that got them into some problems?
Yeah. Well, Wayne, I think, highlighting that their mistakes is actually really important here, because from an antitrust perspective, the law enforcers care about effect. They don't always care about intent. It's not a requirement. So the fact that something is a mistake doesn't absolve you of liability. I want to build on something that Bethany was talking about in responding to this question about REMS specifically, right? Because there are unintended antitrust risk when REMS requirements have the effect of, for example, denying generic applicants access to samples that they might need for like bioequivalence testing, right? Designing a REMS system that requires distribution exclusively through a closed system, and then for some reason declining to have making samples available under that system, that can transform a very legitimate safety protocol into a competitive barrier. That's one thing that law enforcers are looking at. Some other issues, I think, I touched upon this really briefly earlier, but the hard switch problem, right? When a company reformulates a product, and often for genuinely good clinical reasons, right? Whether it's improved dosing or abuse deterrence, when they do that, but the timing, they do that assignment while also withdrawing the prior formulation, right? From an FDA perspective, I would say that's entirely ordinary. But from an antitrust perspective, based upon the timing of that withdrawal and the reformulation, it could have the effect of foreclosing generic competition before it arrives. A very similar theme with, for example, citizen petition timing. A citizen petition filed well before the target approval date for a competing product raises very different questions and concerns than one filed, in the final weeks before approval, especially when those underlying issues were known for years. These types of late filed petitions are something that enforcers have also signaled concerns. And this, I think, just ties into just a broader theme that you may hear me say, is that, the structural problem that I see, the mistake, the core mistake, is that oftentimes FDA teams and IP commercial teams are making decisions on separate tracks and without the visibility of antitrust teams. And the antitrust risk becomes, most acute when those tracks intersect. And the issue here is that those concerns, those problems, often aren't surfaced until an antitrust enforcer starts asking questions.
John, same question. Mistakes. What mistakes are avoidable, but that you see some of your clients making?
Through my lens, right, which is typically a policy and political lens, I find a lot of the decisions that our clients make defensible, right? They're not focused on the bigger politics because they're just one company, and they're focused on shareholder value and bring in more revenue so they can invest in the next generation of treatments and cures and innovating, right? And that's all totally reasonable. The problem is that when policymakers are looking at the top issues for their constituents, drug pricing keeps rising to the top, and they're looking for ways to deliver for their constituents. And when you've got a mistake that is made out there that leads to a story in a newspaper that makes it sound like a poor patient is paying more than they need to, or a company makes it look like they're profiteering, that's a political liability that politicians will use as an asset or think of as an asset. And so I think there's a real tension here, right? It's like, we can't necessarily not operate in a profit maximizing way that risks ceding market share to our competitors or leaving revenues on the table that could be used to invest in the next round of treatments. But at the same time, if the posture that has to be adopted to achieve those profit maximizing results is not that savory, or at least can be framed that way, then you're accumulating political debt, which could be called in at some point. So that's the tension. If I had a solution for it, Wayne, I'd be a richer man than I am right now. But it is a tension that exists and has going to have to be dealt with by management teams as they develop new products.
One final question. We tried something different with this podcast. We asked our audience on LinkedIn to come up with questions that they might have for this panel. And one topic that arose was direct-to-consumer advertising, not marketing, advertising. As we all know, FDA is cracking down on DTC advertising. There have been 75 untitled letters that have gone out since last September 9th when the crackdown began. So the final question for all of you, based on the audience feedback, is how might or should FDA-regulated DTC advertising evolve amid growing concerns about prescription drug costs? Bethany, again, let me start with you. DTC advertising.
This is a long-standing and complicated issue. I could see why your audience asked for us to discuss this topic. The direct-to-consumer promotional activities is interpreted from the policymakers and perhaps economists and perhaps those in the competition enforcement area or advisory that Rahul sits in now, as being a driver of overutilization of drug products, that a patient sees a drug on a TV commercial, hears about it on a radio show or a podcast, or sees it on an Instagram feed. And, even with all the caveats of the risks and the benefits and all the disclosures and all of the safety mechanisms that are built into it, still says, I really want to have that. I need to have that. And makes a call to their physician and gets a prescription in an area that that may not have really been necessary for them. This is, I think, the place where clinical decision-making has always been the interface. The idea that you would, 10 years ago, 15 years ago, have this flow of information, see this advertisement, and then go to your doctor and ask for a particular drug. Most of the time, these are in difficult to treat areas. Cancer drugs, really systemic drugs. Often there you see these advertisements with direct-to-consumer campaigns when the drug itself is very expensive or very new on the market, to break through and let certain populations know about the fact that this is available to them. And you'd have this clinical interface where the doctor would be making a decision with the patient as to whether or not this is the right prescribed product for them. There are economic studies out there that have shown that direct-to-consumer advertising and promotion does result in higher usage and prescribing patterns for those drugs. That means that those promotional activities are effective. And I think that anyone who works in marketing and advertising, even outside of the drug space, would say that they would want their marketing and advertising to be effective. Otherwise, what are you doing? What is your job for? And so I think that what's really interesting is where we are now in a space that it's not so much of this one-on-one relationship where you'd go to your doctor and you talk to a primary care physician or your doctor about this, a week later, a month later. Now the cycle is much more a digital health and telemedicine interface, in my view. You see something that's advertised, you think it's interesting, that it might work for you, you jump on, you figure out where there's a telemedicine provider that will prescribe it for you. You get on, you fill out a form, and it's prescribed to you later that evening without really, a full clinical background and ongoing relationship with a prescriber. That's where I see as, I have a public health background, a master's in public health, have spent a lot of time over, 25 years in the life science and healthcare industry. And I think that that's the place where it starts to become really intriguing as to, is there not enough time and space between that advertisement, the thought, the ability to get online, to get access to that drug and to get it prescribed, and whether that is the right answer for that patient with the right kind of follow-up and safety measures in place for patients. So I do see that there's a trend to look and see that this is to see whether or not that there's ways to pull back on this. I think that FDA has a really important role to play in this to make sure that those promotional activities meet their standards. Whether or not it really has, there's other policy impact levers that could be pulled, I would defer to John and Rahul on that.
I just saw a story about a survey which said that the amount of DTC television advertising since September 9th, since the FDA crackdown, has actually increased. There's been a substantial increase in DTC advertising, even in the midst of the crackdown by FDA. What that tells me is that a lot of what's going on in the drug marketing area and the drug pricing area is really independent even of FDA per se. The environment is changing, the way that consumers and the way that consumers want to access drugs, the way that physicians are prescribing drugs. We're living in a new world. So let me turn to you, Rahul. Same question in terms of DTC advertising was the question that our audience asked. How would you address it in the antitrust How would you address it in the antitrust framework that you've been describing?
Yeah, well, so Wayne, as we just heard Bethany say, this is a complicated issue, and I'm going to apologize in advance for adding another layer of complication here. But one thing that actually gets lost in the broader debate here is that DTC advertising arguably has very real pro-competitive dimensions to it, right? DTC advertising, in theory, it informs patients about available treatments, which increases demand for a therapeutic category. That increased demand can attract new entrants, which can accelerate generic or biosimilar uptake over time. The longer, middle and longer term effect is to reduce prices. The antitrust concern here, not the only one, but one of them, actually runs in the opposite direction of what we're thinking about. Is when DTC advertising is deployed in a specific way to create a brand loyalty that survives patent expiration and slows generic substitution or a patient willingness to try a biosimilar. That could even be the tacit or implied disparagement of generic or biosimilar. I mean, this is where DTC can be a tool for market foreclosure that would raise antitrust questions at the least. The more interesting question, at least competition question for me here, is actually on PBM formulary dynamics. The relationship between DTC advertising spend, rebate arrangements, and formulary placement creates a system, or at least the appearance of a system, where branded manufacturers pay for access in a way that disadvantages generic and biosimilar products, regardless of their clinical equivalence. this is where I would expect to see regulatory attention. And it's, it's where the competition pricing intersection, I think, is the most acute right now.
John, final word on this DTC advertising.
Well, I would say I would note two things. One is that the courts, as I understand it, and the statute that exists that allows FDA authority over these ads are pretty protective of manufacturers' ability to run the ads themselves. The authority that FDA has is to review the ads basically after they have already gone out and to require changes to the ads if they're in violation of the statute, which just says you can't, in short says don't put misleading information out there. And the First Amendment protects manufacturers' ability to run these advertisements. So if you were to reform this, you would likely have to go to Congress and you'd have to look at ways to make these ads less attractive, and probably not by just banning them, because again, that type of law, unless you're going to change the First Amendment, that in this country at least, that's the kind of law that might not get very far were it taken to court. Some of the policies I've seen are taking away the ability of manufacturers to deduct spending on advertisements for tax purposes, to create a disincentive in adding them. I think Rahul makes an interesting point about these actually being pro-competitive. I don't know if there's consensus yet that DTC advertising is necessarily a bad thing. We've seen bipartisan support for it, but we haven't seen majority support for it yet in Congress. And it'll be interesting to see what the, say, 2028 competitors for president say about this. President Trump's Health and Human Services Secretary has come out as being against these ads, but I haven't heard the West Wing or the president himself say he would work with Congress to ban them or to make them not tax deductible anymore. So it might be the next round of leadership in Washington that ultimately decides whether or not this is an issue that rises to the top of the political agenda.
Yeah, the conventional wisdom is that the FDA, quote, crackdown, the issuance of untitled letters will continue, but that it's unlikely, at least for this year, that there will be any effort to do anything in Congress or elsewhere with regard to the basic law which enables FDA to regulate these ads. So on that note, it's time to thank the guests here. Bethany, Rahul, John, you've done a great job. That was a very, very interesting session that we just had. It was a great start to the 4-part series we're doing in collaboration with White Case and with BRG. I want to thank our podcast creator and executive producer, Michael Evan Epstein, our assistant producer, Sam Hoffmeister. If you want to find out more about the podcast, visit our website, fdawatch.net. That's fdawatch.net. And if you don't want to miss parts 2, 3, and 4 of this series on drug pricing or any episode of FDA Watch, the only way to assure that is to subscribe. fdawatch.net. It's free. Thank you all for listening. As we say at the end of every episode of FDA Watch, if you really want to watch what FDA is doing, listen to FDA Watch. This is Wayne Pines.